but frankly, they practice in the same district, and chance that you may not be, and your nomination may not go forward, they could jeopardize, they fear that they could jeopardize their client's prospects. And so some of what we've heard is that for people who practice in Camden County is that she rarely uses her discretion to seek alternatives to prosecution, and that she's been characterized as an overzealous prosecutor. And some examples of that, and I think you have some of this before you in testimony, is failing to settle some cases in quite is that my 1 minute mark? Okay, unfair plea deals, and also the investigating the Frank Lab scandal and refusing to turn over exculpatory evidence. Now, I don't want to speak to the truth of those because I can't, but I felt compelled to tell you about them. And if this is someone who has been tough on crime, that is exactly the opposite direction that our Commonwealth and the nation is going. And for one statistic that I hope you all know, but upwards of 80% of people incarcerated in Massachusetts, and any correctional administrator will tell you this, have mental health and substance use issues. 80%. So it is irresponsible, honestly, to appoint yet another person who lacks professional, clinical, or any other meaningful expertise in mental health and substance use disorders. The fact that there's only one person out of 7 on the board with this should strike us as reprehensible, if not reckless. And I know you're giving me my time, but if I can, other people have been able to speak for much longer. And
so you're keeping everybody else from trying to get this done today, but go ahead.
Would anyone else like to hear me speak?
Yes. Go ahead.
Thank you. Importantly, the board has a broader statutory authority, or obligation, I should say, beyond holding parole hearings and just making decisions. The parole board has almost completely ignored its responsibility to ensure that people who are out on parole have the tools they need to succeed. This is under statute. It's been completely ignored by the board. In addition to a recent SJC decision in 2016 saying that they have affirmative obligations to help people who have disabilities seeking parole and who are going out on parole. This is being completely ignored by the current parole board. Part of the reason is because we lack the expertise on the parole board. Just 6 months ago, many of you heard testimony opposing Gloria Maroney, another nominee to the parole board. And what I heard, I was there, and what I heard was kind of a fear of rejecting that nominee. And I just want to push back on that a little bit, but also to tell you that the Governor's Council is not a rubber stamp. And I really hope that you all feel that, but during that hearing, it's not what I felt, not what I heard from you all. What I heard very much was that you felt your hands were tied, and this is quoted in State House News, your hands were tied, and you didn't feel like you had the power to reject this nominee, that what you were really considering was whether or not this person was competent. And I've also heard the word qualified. I would like to push back on that a little bit, because I actually do not think that she's qualified for the job, not because she's not competent, not because she's not good at what she does, but the parole board is currently not qualified to assess the people before the parole board. 80% of the people going before the parole board are not being assessed by a board that is qualified to understand their issues and to understand what they need to succeed on parole. And what you should be looking at, what the question really before you is this person the right person for this job now? If there had been 3 nominations ago, she probably would get in. And I'm sure she's a good person and a good mother, but that's not what you're doing. You're assessing whether or not she's the right person for this job. I'm an executive director. I hire people. That's what I have to do. I'm not looking to hire competent people. The reason why the Attorney General Office and the government has people who recruit diversity is because we need people with different levels of expertise and different levels of understanding of the community to help us do our jobs well. And that's what we're lacking on the parole board. There are people's livelihoods that are hanging in the balance here and are resting on your decision. This impacts people on a daily basis. It's very, very important. And I hope you make the right decision.
All right.
Thank you. I do appreciate you coming in and your comments. And although I was a cop for 30 years, I do represent people, criminal defendants. And I do believe that good people deserve a break. What I don't think was fair and appropriate was you saying basically that she committed prosecutorial misconduct, is what I heard, and that people are free to come forward. If someone has evidence of that, they need to come here and be cross-examined. It's not fair to just say things about other people through hearsay and besmirch someone's career and campaign.
I am not, actually, I wouldn't have said that if that testimony hadn't been submitted to you. So you do have that testimony before you, someone submitted that, and I absolutely, and again, that's why I referenced it, because it is not coming from my own experience, and I'm very, very clear about that, but it is coming from someone else's experience who submitted that testimony.
Okay, that's like people putting something on Facebook. They send a letter and they can't be cross-examined. If they really have credible evidence, they need to be here. They need to be asked questions.
They submitted that testimony to you.
I don't put any credibility in something that somebody puts in writing, like I don't put credibility in things I write on Facebook, same thing.
What?
Come here and be, if you want to be a witness, come here so you can be cross-examined. It's not fair to her to just say things blindly and throw them out there. That's my opinion, and I'm entitled to it.
Okay, Councilor Duff.
No.
Listen, folks, from the audience, no comments, please. I'm trying to run a meeting. This is not a sports event where people applaud when they see somebody score points. This is a serious hearing. It's conducted in a certain way. I would just appreciate it if there's no further comments from the audience. Councilor Duff.
I greatly appreciate your testimony because frankly, of all the counselors here, I'm probably the one that pays the most attention to the Parole Board and does the most research. And I wholeheartedly agree that what's been going on in the last 4+ years is egregious. What is stunning to me is that there is 4 times the staff right now than there was under the previous chairman, and yet the decisions are, some of them are a year behind, which I'm a little surprised there hasn't been a class action civil rights suit filed myself. I mean, I'm not an attorney, but I find that stunning. So I thank you for your testimony, and I do want to let you know, I try not to talk a lot because I want to listen to people, but I hear what you're saying loud and clear. And I've been very clear to the administration that I think for whatever reason there is a hostile work environment at the Parole Board. I get calls from not from people on the Parole Board, but staffers a lot. And they are afraid to come up. And they are afraid to testify. And the fact that you get letters, I disagree with my colleague. I think we have to take them very, very seriously. In the last gubernatorial administration, when they did not take this stuff seriously, they ended up with a lawsuit that they are still fighting. And I have said to the Baker administration over and over again, you are headed down that path because you just have your head in the sand about this. And I don't frankly understand it because I think being on the Parole Board is more important than being a judge. You literally have somebody's life and their future in your hand. And in my opinion, and then I'll stop at my diatribe and try to be quiet so everyone else can go, but we have created a very, very serious public safety problem and hazard in this state. And I think when it blows up, it's going to be cataclysmic.
I appreciate the testimony. I think that you made a lot of valid points. I completely agree with Councilor Ferraro with respect to the issue process on this. That is a very, very serious application. And if I were to consider something like that, I would need some substantial evidence to support that. I deal with prosecutors every day of my career, and it's extremely rare that I find one that isn't dedicated, that isn't honest, okay? And if there was a prosecutor that engaged in prosecutorial misconduct, there would be serious consequences related to that. So I don't think it's fair at all. Throw that out there, either through the letter or your testimony without something to back it up. I haven't seen anything at all in any way, shape, or form that suggests that she's anything but ethical.
Well, And to that, I would just say, it's someone else's letter, and
But-
you should engage in
Okay.
that, and
I
if
read the
you
letter.
get,
I-
but also if you get testimony that is different, positive on someone's character, and negative on someone's character, they should
I
should
read,
be
I read the
considered.
letter, and it didn't back up the allegation.
Mhm.
And it's a very serious charge, and I put absolutely no credence in that particular charge because I haven't seen any evidence of it. And as I said earlier, I've received countless emails, I've received a number of phone calls, and, you know, there's nothing to indicate that Ms. McCarthy, Attorney McCarthy, is anything but an ethical prosecutor, and I'm not going down that road. My reservations are very different than anything to do with her character. I'm not imputing her character at all, and I don't think it's fair to do that, based on what we have before us.
Likewise, point well taken.
I can only say this, when I was running for mayor, we were at a Jewish community center, and this man got up and accused me of being anti-Semitic. So I said to him, why don't you ask my boyfriend? He's Jewish. It's just not right.
I don't think that's what I said, I referenced something in the letter.
No, but that's the point. If it's in a letter and it's not something of your own knowledge, it's really not fair to say. It's like she's being singled out because she's a prosecutor. And if people didn't say, hey, wait a minute, she's a good person, and I didn't say, oh, why don't you ask my boyfriend, he's Jewish.
So just with all due respect,
I'm not
a
gonna
number
get
of
into a
people,
debate.
a number of
I'm
people
not gonna get
raised
into a
things.
debate. You already went past your time. Let's get on to the next
I
person.
have a question.
Go ahead.
I'm here to not be able to respond to what you're saying.
Okay, let me ask you, what letter were you referring to?
I'm sorry?
What letter were you referring to?
It's a letter that was, I think I have it in my bag, submitted by, I think, Ramos is his last name, the public defender in Hampton.
Yeah, Alexander Ramos. I have a letter here, yeah, I'm gonna read it. into the
But,
record.
but that's not the only letter that I received. That's, I think, the only one I know of that was submitted. You may have gotten others.
Yeah.
But we also did receive comments from people raising some other concerns. And it's the same, if I receive 30 letters from a client telling me that a guard is beating people, that is worthy information to me. And so I felt that you would want to benefit from what we have heard. It is hearsay, absolutely. My intention is not to smear someone's reputation, but to bring information to this council that is charged with making a very important decision. That's all.
Well, my opinion is, there's nothing wrong with that. You know, we listened to witnesses, we listened to 3 of them today. We have no idea whether what they told us is truthful or not. I assume it's truthful, because they came in here and they talked about it. I assume that people that I know in Western Massachusetts that spoke to me about the candidate are telling me the truth as they see it. So, you know, a lot of people come in and they say all these flowery things about some, and he's not particularly this candidate. I have no way of knowing whether that's accurate or not. We get letters all the time on behalf of people. I don't know whether that person writing the letter knows what they're talking about or is telling me the truth, but I accept it for what it is. Some piece of information that I'm free to say, hey, I'm not putting a lot of stock in this hearsay stuff, but I want to hear it because that's what my job is, to hear everything, good and bad. So I appreciate you coming in and talking and putting what you have to say on the record. Whether anybody takes it into consideration and votes a certain way, I have no idea. Some will, some won't. That's the way this whole business works here. But, you know, it's not like a trial that you come in here. I know that people were sworn under oath. I can tell you now that means absolutely nothing. We don't have the power to swear anybody in. The legislature has to give us that power, and they never did. It was a Supreme Court case on it about 9 years ago. We don't have that right, but we do it. I assume everybody that comes in here is telling me the truth as they see it. I assume that. I assume this nominee is going to tell me the truth as she sees it. And unless I have absolutely evidence that she's lying or somebody's lying, I would never say somebody is lying. I don't do that. So these hearings are a mishmash of information coming from all sorts of people, and counselors will filter it the way they want to filter it. I've read his letter. I think he's a CPCS lawyer. He's got every right to write a letter, just like people in behalf of the nominee wrote letters. Nobody's questioned where that information came from, so he signed the letter. I don't know how many letters I get that people don't sign. I don't know how many calls I get that people don't give their name. And I don't credit that so much because they don't tell me who they are, so I don't know what they're doing. But when somebody writes a letter, he's a lawyer, member of the bar, CPCS lawyer writes a letter, I want to read it. Okay? I thank you for coming in.
All right, next witness, Laura Massey.
Good afternoon, councilors. My name is Laura Massey. I'm here today on behalf of the Mental Health Legal Advisors Committee. And in the interest of time, I'm going to largely read from a prepared statement of which I have copies for each one of the councilors. Sure. So I'd like to follow up largely on a court case that was referenced by Ms. Matos in her testimony. The SJC decision in Parole versus Massachusetts Parole Board, which was issued in 2017. I'm not sure if all members of the council are familiar with this case. In it, the SJC provided detailed guidance regarding the parole board's obligations under the Americans with Disabilities Act and cognate state law provisions that protect the civil rights of people with mental health and other disabilities. In Crowell, the SJC affirmed that the parole board has a broad legal mandate to provide reasonable accommodation to prisoners with disabilities, and that this mandate applies throughout the parole process, not just within the hearing, but also in the preparation steps. The board's obligations include to provide an expert or other assistance to help, I'm quoting here from the opinion, providing an expert or other assistance to help the prisoner identify appropriate post-release programming, considering whether there are risk reduction programs designed to reduce recidivism in those who are mentally disabled, and providing a professional evaluation of the prisoner's condition and recommendation regarding a post-release plan that might diminish the risk of recidivism. The SJC obliged the parole board to identify prisoners with mental health needs, assess and develop clinical recommendations, and provide robust support in creating a parole proposal. This mandate requires the board to develop, evaluate, and monitor the implementation of policies, procedures, and practices that will allow for timely identification and accommodation of the needs of prisoners with mental health disabilities. And as we've already heard, they represent a significant component of the prison population. Discharging this mandate requires that the parole board include a sufficient balance of persons with the professional and educational background and expertise to understand the needs of this population and how those needs can be best addressed to avoid the kind of discrimination prohibited by the SJC. The Crowell decision heightens the need to augment the number of board members with relevant clinical experience, not to stop at the statutory minimum of one such board member. This includes expertise in substance use disorders, mental health, brain development, and the impact of trauma. While an understanding of what is needed to promote public safety is important on the board, that is more than adequately represented with the current composition of the board. An additional experienced clinician is sorely needed, not only to enhance the board's ability to come into compliance with disability civil rights laws, but also to render the board more well-rounded and representative of a variety of professional perspectives. A more balanced membership will lead to better decision-making on individual parole determinations and also to improved policies, practices, and procedures to provide correct evaluation and accommodation to prisoners with disabilities at all phases of the parole process. Recent history of the parole board, as has been referenced here today, underscores the need to mitigate the dominance of persons whose experience derives from a punitive model by adding board members with insight into rehabilitation and reintegration. The current parole board rarely, if ever, utilizes its authority under 120 CMR 300.05 subsection 3 to schedule mental health evaluations for prisoners to assist in its decision-making. There were 0 such appointments in calendar year 2018. In the 20 months from May 2017 to January 2019, the board referred a total of 34 prisoners for appointment of counsel in parole hearings due to mental illness or cognitive impairment, whereas data from the Federal Bureau of Justice statistics indicate that at least 56% of state prison inmates report mental health problems. 34 certainly is not 56% of the number of people who came before the parole board during those 20 months. We also understand that in some cases, the board did not become aware of significant mental health issues until a parole release hearing was already underway. Although we're glad that the board has, at least on occasion, flagged the need in these cases, The failure to come to what should have been an obvious conclusion in advance of the hearing and provide the required accommodation can cause significant delays in ensuring timely hearing with benefit of counsel. Failures such as these, as counselors may be aware, have exposed the board to federal scrutiny. The Department of Justice is currently investigating board practices to determine if they violate the ADA and other civil rights laws. In the wake of the Parole decision and in light of the pending DOJ investigation, it is imperative for the board to strengthen its capacity to render required reasonable accommodation for parole-eligible prisoners who will otherwise spend extended time in prison due to health conditions over which they have no control. Thank you.
Thank you. Any questions? Thank you. Appreciate it.
May I submit my
Absolutely. Just right up here. Colleen. Nancy? Jeannie. Yeah, you're saying.
Speak today, yes.
You gotta do the microphone.
Again, my name is Colleen Maney. I'm a third-year law student at Northeastern University.
Speak right into the mic.
Better? Okay. My name is Colleen Maney. I'm a third-year law student at Northeastern University School of Law. I come before you today as a student attorney at the Prisoners' Rights Clinic at Northeastern University. And I'm speaking on behalf of myself and several of my colleagues and fellow students that have worked with that clinic. This past winter, we had the opportunity to represent 8 clients before the parole board. As a result of that, I both represented a client before the parole board and had the opportunity to observe the parole board conduct several hearings. As you can imagine, as a second-year law student at that time, it was a little frightening, the prospect of having to present before the parole board. The client that I represented was serving a life sentence for second-degree murder. But there were a few things that quickly became apparent with my experiences that really fueled me in that endeavor. I was first shocked at the low parole rates, which I know you're all aware of. The last I checked, around 2017, those were in the single digits for lifers. And I don't believe we have any updated data on that, but by all anecdotal accounts, that has continued to plummet. I was shocked by the inefficiency of the board, which I know has been described to you in detail today. But particularly that the board has been taking a year to rule on lifer decisions. And I was really shocked at the punitive and adversarial nature of the proceedings before the parole board, a board whose mandate is to seek rehabilitation. My client's hearing lasted for 3 hours. He was questioned for 2 hours, and the vast majority of those questions were about the crime, which occurred 27 years ago. The only questions that were asked of him about his rehabilitation were from Dr. Charlene Bonner. And that was true for nearly every single one of the hearings that I witnessed during my time with the client. And this, I know you know this, but this is impacting the outcome, the nature of the Massachusetts parole system. It is broken, as many people have referred to today. And this is really apparent, not just to us in the state, but those outside of the state. There was a February 2019 report from the Prison Policy Initiative that graded the Massachusetts parole system with an F. And that's something that I think we should be ashamed of, not just for the criminal justice system, but system of fairness for all of our citizens across the state. So to return the parole board to its legislative mandate, really to move back towards any sort of effective parole system in this state, we need a well-rounded, diverse board that believes in rehabilitation, that can meaningfully assess applicants' rehabilitative efforts, and can design and administer effective parole systems. And I mean, this is a fiscal imperative to break it down to dollars and cents for Massachusetts citizens, because it is extremely costly that we're keeping folks who could otherwise be eligible for parole in prison. But more importantly than that, it's a fairness imperative for all folks to have parole as a just, functioning facet of the criminal justice system in this state. So on behalf of my colleagues, I would encourage you to keep this in mind as you exercise your oversight authority in this nomination. Thank you.
Any questions?
Thank you for your testimony.
One thing, we don't have control of the parole board in terms of how they operate. The only thing that we do is vote yea or nay on a candidate.
Absolutely. You're the
Okay.
gatekeepers here.
So, I think that we can carry the water back to the governor, and governor. But as it relates to our authority and our power, it is strictly to vote yea or nay.
Yes, and as I see it, with all respect, Counselor, I believe that you can demand that the nominees that are put before you can change the nature back to the mandate, the legislative mandate of this board. And I think that that is a significant power, limited perhaps, but significant.
Thank you very much.
With all due respect for my good friend from the western part of the state, I do think we have a lot of power with respect to that issue. You know how many people have come before this council for reappointment?
Mhm.
You know how many people that this council has voted to reappoint? Every single one of them. So when you say we don't have power, we have enormous power. We have enormous power. All these people that come back.
I'm sorry, that was
Go away, time's up.
It's 5 minutes.
I was doing it within your 5 minutes.
We don't have a lot of power over judges, those are lifetime appointments. These are not lifetime appointments. We have enormous power. That's all I wanted to say. Thank you.
Thank you.
Thank you for your
Sorry
time.
about that. Hope the Weitzman.
I'm Hope Hop. I'm going to defer to my fellow
Okay, so it was 2 people.
Yeah.
I just thought it was one with a long name. Okay, so you are saying you're not going to testify, or you want to testify next? Okay. So you're Ms. Weitzman. Okay, great. Thank you.
We are both part of the Social Work Association.
Microphone.
Microphone.
We are both part of the Social Work Association, NASW it's called. And we are been active for a long time, watching things in the rural area. Now we are here. We have a statement that's been emailed to you. Too. And we start out saying that we become more concerned about the composition of the board, continued nominations that do not include enough people who have backgrounds, others who are speaking about. And this is our belief that there should be a minimum of 3 to 7 parole board members who should have required 5 years of training and experience. And they should be in, those 3 should be in the currently underrepresented fields that are specified by law: psychology, psychiatry, sociology, social. We are aware that the current board only has 1 such person, and she's not been confirmed to continue. She's hanging and not currently in the board officially. We're concerned that she isn't continued, and we have a new person that's been nominated. We will just have 6 of 7 of the board members will not have the requirements that we believe you should have more of. And we think we should consider 3 should be your criteria goal. And the goal would have to be if you don't realize you are not the nominators, you're not the decision makers, who comes in before you. So I would like to just say something about the expertise that we feel our type of human service workers, those people with these backgrounds, this training, and this experience clinically have. We think they will bring knowledge of mental illness, substance use, trauma, adolescent brain development, adult maturation, and family and community systems that would bring them to the board. We believe that this type of background will give the board compelling kind of capacity, ability to assess emotional and cognitive changes during incarceration. We talked about looking to the future. What do people come to be at the time they come before the parole board? What are the processes that could have changed them? The ability to comprehend the impact of some changes on crime-free living if parole is granted. The ability to take into account the effects of aging and health conditions. And the ability to help plan human service community supports that would be appropriate for individuals that are released to the community. It's been mentioned that these types of training would help people interview better, bring different issues before the board that wouldn't be considered otherwise, might relate to the people coming before the board in a way that would be more compassionate, but more effective, because it would bring out the strengths of the people and relax. So there are other things that I could have included. We believe that perhaps many of you have proven to me today that many of you on the board do know that there's a deficit. That you do know that these capacities are needed, that maybe become worse and worse as a result of there not being on the board these types of people. We know you don't nominate, but we urge you to, as some of you say you have, register concern. Register publicly. This will be reported in different ways what you're doing today. Let the governor know, let the governor's staff know, let Lieutenant Governor know, chairs you and it's a decisive vote. Register your concern about this pattern of nominations. And we also think that you could consider this to alter the current pattern of imbalance representation. There's an imbalance in representation. Would be for the council not to act on new nominations until persons with strong behavioral health backgrounds are nominated and hold a reasonable number of seats. Now, you could somehow indicate you provisionally support this current nomination. You like this person, but you don't want to have to vote now. You want to defer that decision until maybe someone else would fill the spot first. I'm not saying it's feasible. That's what I have to say.
Thank you very much. Any questions or?
I just want to point out, we have a 30-day statute that we have to follow. We don't vote within 30 days versus deemed appointed. So we can't just.
You can't say up now, you can't say.
Nope, can't do what you're asking.
There's another thing that I've heard about is in the law. The governor could ask a panel to be appointed to offer him or her nominations. I think you should all ask for that panel to be, because it doesn't seem that the governor has a wide array of opportunities to appoint. He doesn't seem to have enough people some of you want to have be among your nominees. So ask him to convene and create this panel.
My only comment to that is that the governor knows exactly what he can do and who he can appoint, and he has to have the political will to do it. And I'll leave that up to you to make the decision whether you think this administration has that political will and cares about criminal justice reform and people succeeding. I'm not passing judgment on that, but I will say to your point about Dr. Charlene Bonner, I think one of the important things that the administration misses, and maybe my counselors do about her, is it's not just that she is an expert, and I don't mean just took some class and got a certificate. I mean, this is somebody who has over 10,000 hours of real medical work to do the work she does. But what she is bringing to this board, and why some of us are deeply disturbed that we have not yet seen her reappointment, is an institutional knowledge that is needed more now than ever. And so if you all folks really care about this, you can talk to us, but you all should be talking to the governor and lieutenant governor as well. Because I talk to them all day long about this, and and you can see how far it's gotten me. And you can look up all of our individual votes to see how we've all voted for these people, to see if people say what they say is really what they do. Because it's one thing to be in a public hearing and say rah rah. It's another thing to put your money where your vote is.
Well, I appreciate if you say you've been talking to the governor and lieutenant governor, I assume, and you're saying more of us should do that.
Right.
I agree. And what about this panel? Speak to him about that. I mean, that's
He's never
another
gonna
argument.
do it.
And maybe he'll never do it, but if we don't ask, if we don't say we should.
If I may?
All right, okay.
Yes.
One of the things I want to say is that when you have a difficult nomination, because this is difficult because it's another prosecutor, that's what makes it difficult, not about her. Everybody shows up. When we have somebody that needs support, like Dr. Bonner, if they nominate her, nobody's here.
What hearing took place for her? What hearing took place for Lee Gartenberg? I would have been the first to be there.
Right.
I know the
No, I
person.
understand
I watched his
that.
work.
And very frankly, and everybody in this council knows, I've been pushing for Dr. Bonner's reappointment. A I'll give you.
But how do I know when to go and support it?
The same way you know it now, the same way you knew that this nominee.
Is there gonna be a hearing for her
Of
reappointment?
course, you know, and I hope that if she
When will
is
it be?
I hope if she is renominated,
Well, we thought she could be dropped without her having a hearing. She could just be dropped. When did they drop
she's
Lee
dropped, but
Larkberg?
she's nominated. I hope that
She's been
people show,
nominated,
I
but
hope
there's
people
been no
show up for
hearing.
that as well.
Well, they dropped Lee Gartenberg, there was no hearing. So how are we supposed to speak up on it?
I understand that.
Very frustrating.
Thank you. Again, I disagree with my colleagues. We have enormous power. Forget the governor, forget the lieutenant governor, it starts right here. If you get 5 votes, guess what? The governor will do the right, the governor will do the right thing. We'll have more people of social science background. It's all, hold on, whoa, excuse me. It's all about us. Don't forget, call the governor, lieutenant governor, right here. There's 8 of us. If you get 5 votes, which, you know, I'm not optimistic. If you get 5 votes, guess what? The next one will be a social science person with a background. It's about this body. What is this body going to do? Forget the governor. Excuse me, man. Whoa, I haven't finished.
I'm not gonna speak till you stop.
Okay. Forget the lieutenant governor.
He does that to me too, so don't.
Forget the governor. It's about this body. There's a lot of speeches today. Let's see if we have the courage to do the right thing. The vote is next Wednesday. You all can show up. Let's see if we have the courage to do the thing, to do it next Wednesday. It has to go on. It has to go on next Wednesday. Okay? And I'm telling you, you know where I'm coming from. I don't know if we have 5 votes. That's what we need. 5 votes. If we don't have 5 votes, this nominee will go forward. 4-4 vote, she goes forward. But that's what it's about. It's about this vote.
Well, it has to be a number of places because we haven't had positive votes in the past that some of us have felt you should take as a board. I know the conscience issue. People are saying they don't want to vote against a good person who has qualifications, blah, blah, blah. They don't want to take that vote. And I do hope we'll have 5. I think you would have more than 5 if people really heard what we're saying. That the board has been in a deficit. The board has been functioning well. It's had many costs. And many of us have very good information to offer you about what we think these people who have different qualifications would offer and how much they're needed. I hope we'll have more. 4, we need 5. Thank you.
Thank you very much. The next witness is, I believe, Eugene Kim. I gotta see. Break without taking. You wanna take one? Or just
10-minute break, 10-minute break.
well, I don't want. I'd rather have it. I'm just going to ask Councilor Ferrara to take over.
Okay.
Yes, but you're on time here.
Good choice, good choice.
Okay.
Great choice.
Put the timer on. These are gonna start moving now.
I don't know how to work it.
Okay,
Start.
start. You're on.
So good afternoon, councilors. I prepared a statement that I'll be reading from. So my name is Eugene Love Kim. I'm a recent graduate from Northeastern University School of Law, where I participated in the Prisoners' Rights Clinic. So during my time in this clinic, I represented a state prisoner for his parole release hearing, and I also assisted other potential parolees before the full membership of the Massachusetts Parole Board. Consequently, I had the opportunity to witness the parole board and am familiar with their decision-making process. I'm here today to state my opposition to the appointment of Karen McCarthy because I believe we should not have another person with a law enforcement background serving on the parole board. At this time, the parole board primarily consists of individuals who have a background in law enforcement. Former state prosecutor, 2 former Department of Correction employees, and a former parole staff member. Parole board only has 1 member who seems cognizant of or even cares about the issues that prisoners face. Those issues include lack of education, substance abuse, and mental health problems. We should seek to find a candidate who not only understands the issue that the prison population faces, but is also equipped to address these issues. After all, the purpose of incarceration and parole is predicated on rehabilitation, not punishment. Candidates that should serve on the parole board are individuals who have backgrounds in education, substance abuse, and mental health treatment. In addition, I want to note that the parole board is a public position that requires great responsibility. Many of the current parole board members do not appear to take their job seriously. I witnessed this during the parole hearings that I attended. There were many occasions in which only a few members were present for the hearing. During my client's parole hearing, many of the members were having private conversations. They were on their cell phones when he was testifying. To me, that demonstrated a lack of respect to all parties present. The client's family, victim's family, the criminal system, and to the Commonwealth. This sort of behavior is wholly inappropriate, and in the future, better and more qualified candidates must be sought so that the parole board members conduct their work earnestly and diligently, so that the board can be held accountable for their job. Another issue that the current parole board has is that it does not render decisions in a timely fashion. Our clients who all serve life sentences often wait at least a year to receive an answer from the parole board regarding their request for parole. We need a parole board and members who understand the importance of scientific findings and risk assessments when rendering these decisions. Because currently, the board uses arbitrary measures to determine whether prisoners should be eligible for parole, such as demonstrating a certain level of responsibility and remorse for their underlying crime, not measures that assess whether a prisoner is rehabilitated or likely to reoffend. Again, this is contrary to best practices, as incarceration and parole are both designed to help rehabilitate inmates so that they're able to return to society as informed citizens. I believe appointing Ms. McCarthy to the parole board will not address any of the issues that the parole board currently neglects. By continuing to appoint individuals with a law enforcement background, the Commonwealth will allow these issues to continue instead of fixing the system. Maintaining the status quo will not only fail the incarcerated population, the victim, and the families, but it will also fail the fundamental concept of justice.
Thank you very much, sir. Any questions for this witness? Do you have a job? Good. Thank you, sir. Next witness, Victoria Keller. Okay. I know there's two of you, now that I figured that out. There's a Victoria Kelleher and a John Amabile.
It's actually, it's John Mount.
I think you know.
Are you gonna read his speech?
I couldn't read his writing.
Kidding.
Hi, good afternoon, members of the council. Thank you. Can you hear me all right? My name is Victoria Kelleher. I'm the incoming president of Massachusetts Association of Criminal Defense Lawyers. I certainly, I'm here to echo a lot of what you've heard here already. I know it was just mentioned, one thing that, a couple of places that I looked to as I was preparing for my testimony here today. One was the parole board website itself, to see what the figures are that they are dealing with. And the other is the Sentencing Commission report and the goals of sentencing that we look to in the Commonwealth of Massachusetts. And I would suggest that the parole board's work is woefully, it's really, really missing the mark in these areas. I looked initially at the statistics, and I think some stats were provided earlier. What I read was that there are essentially 50% of those seeking parole relative to a House of Corrections sentence were paroled. I would suggest that that number is way, way too low. And as to a Department of Corrections sentence, it is 22%. So there is no way that these kinds of figures are meeting the goals of criminal justice. If you have people that are being paroled directly to the street that are being released directly to the street without parole. Of those people, 62% are white, 19% are Latino, and 17% are African American. And these numbers obviously do not reflect the incarcerated population, which I took, and those statistics were from the website from the parole board. For every one person, there are 8 people who are Black who are incarcerated. For every one white person,
there are 5 Latino or Hispanic people who are incarcerated. So again, these statistics that show that beyond any doubt that there is a real disparate impact on the way people are being paroled based on race in this state. And that really needs to be addressed. And what the Sentencing Commission, when it began to look at the what they really saw as their mission, they saw as their mission a comprehensive, evidence-based approach. And when I looked at the Parole Board website, it talked about using actuarial tools. I don't know whether, in fact, they rely on actuarial tools. And from what I've heard here today, it certainly sounds like they are really not putting a lot in that their decisions are, in a lot of ways, are very arbitrary. But this is what the Sentencing Commission was looking to, is comprehensive, evidence-based approach. And I think for that, we need to have people that are well-versed in the social sciences. These are the people that understand how to look at the actuarial tools, how to apply them. And what you see when you look at these actuarial tools you see that that there is, they're being used in many, many respects. And I practice both in state and federal court. There is a huge move in this direction to look at these actuarial tools. But they're being used in a way to hamper release by categorizing people as medium risk or high risk or whatever it is. And what these tools are really meant to do is not just categorize people as either a medium risk or whatever it is to reoffend, but to look at what kinds of services would really help people in parole. That is not being done as far as I know. And how can it be done? Because you don't have people that are well-versed in what kinds of services are going to be best able to meet the needs of those who are parole eligible. And in particular, people, so when we look at recidivism and these actuarial tools themselves there is a huge disparate impact that has been shown in the study, in the science, and looking at these.